Welcome to the debate. Today, we are examining the fundamental architecture of American constitutional law. Specifically, we're looking at the profound philosophical tension between legal positivism and natural law.
Right, and we are centering our discussion today on a highly specific, well, a very provocative question.
Exactly.
Under the Supreme Court's own established precedents, does the exclusive enforcement of legal positivism actually function as an established religion in violation of the First Amendment?
It is a massive question, and it fundamentally challenges how we view the power of the state. And this analysis emerges directly from a series of formal addendums and essays authored by Zachary David Infield. We're looking specifically at texts titled The Court's Own Words and The Kamikaze Argument.
Yes, and those texts assert that the American legal system has essentially, through its reliance on positivism, unconstitutionally established the religion of state sovereignty.
I will argue that legal positivism meets every functional criterion of a religion under Supreme Court precedent, and furthermore, that it logically self-destructs, requiring an uncompromising return to a natural law framework.
And I will argue that positivism is a neutral, procedural necessity for a functioning pluralistic society. Applying individual religious tests to institutional legal frameworks is, I believe, a profound category error.
So, to really ground this, we need to look at what the Supreme Court has actually said about what constitutes a religion, because it is not just about a belief in a traditional deity.
No, definitely not.
In the 1961 case Torcaso v. Watkins, the court examined a Maryland requirement that a notary public declare a belief in God. The court struck that down, and in doing so, they explicitly expanded the constitutional definition of religion.
Right. That was the famous footnote, wasn't it? Where they recognized belief systems like secular humanism and ethical culture as qualifying as religions under the First Amendment.
Precisely. And that laid the groundwork for what happened 9 years later in Welsh v. United States. This is where the court formalized what legal scholars call the functional test. Elliot Welsh was seeking conscientious objector status to avoid the draft, but he explicitly crossed out the word religious on his application. He said his beliefs derived entirely from history and sociology.
And the court essentially said that didn't matter, right? They looked at how his beliefs functioned in his life rather than the label he put on them.
Yes. They held that a belief system is a religion if it occupies in the life of its adherent a place parallel to that filled by the orthodox belief in God. In other words, if it functions as their ultimate authority, if it governs their moral reality, it is a religion for constitutional purposes. And Enfield's text takes this functional test and applies it directly to legal positivism.
Which we should probably define clearly for the discussion. Legal positivism is the doctrine that law is simply whatever is validly enacted by the recognized legal authority. There is no higher moral standard, no natural law, that possesses operative legal force to override those enacted statutes.
And when we apply the Welsh test to positivism as an institutional framework, Enfield argues it answers yes to every structural criterion of an established church. Think about what it does. It provides a governing account of ultimate reality, declaring that enacted law is the final, undisputed truth. It occupies the place of final authority, locating that infallible power in the Supreme Court. It demands mandatory adherence from all citizens, backed by the coercive physical power of the state. And crucially, it systematically excludes competing frameworks. It specifically silences natural law.
So the argument is that by enforcing positivism as the exclusive lens for constitutional interpretation, the state has unconstitutionally established a secular theocracy.
That is exactly the argument. It acts like a religion, it functions like a religion, and it demands the absolute submission of a religion.
The argument is undeniably provocative, and I appreciate the elegance of Enfield's framing here. But structurally, it rests on a severe category error. We really have to look at what the Welsh test was actually designed to do. It was built for individual conscientious objectors seeking statutory exemptions from military service.
But a test of function is a test of function, regardless of who's being evaluated.
I have to disagree there. It was a diagnostic tool to measure the sincerity and weight of an individual's personal conscience. It was never intended to be a tool for evaluating the operational framework of a sovereign government. Applying a test built for individual drafted citizens to the foundational architecture of the state itself is, well, it's mixing apples and constitutional architecture.
I don't see how that invalidates the structural comparison, though. If a system functions identically to an established church, the fact that it's a government doing the establishing makes it a First Amendment violation, not a category error. I have to stand my ground on the functional reality of what positivism is doing.
I come at it from a different way. If we look at what legal positivism actually does in practice, it is purely procedural. It claims no ultimate moral reality. It merely states that for a society to function, there must be a recognized, agreed-upon process for enacting laws. Think of H.L.A. Hart's famous rule of recognition.
Let's unpack that for a moment.
Sure. Think of Hart's rule of recognition like the rule book in a game of chess. The rules of chess don't tell you if moving a knight is morally good or evil in the grand scheme of the universe. They just tell you if the move is legal according to the game we've all agreed to play. Positivism is doing the exact same thing with our laws. It tells us how to recognize a valid statute, not how to govern our eternal souls.
But that is exactly where the analogy breaks down, and I firmly stand my ground on this.
How does it break down? It separates the description of legal obligation from moral normativity. Hans Kelsen called this the pure theory of law. It's completely neutral.
I'm not convinced by that line of reasoning because the claim of neutrality is positivism's most effective and, frankly, its most dangerous concealment. A belief system that claims to be merely descriptive, while simultaneously prescribing what counts as authoritative, what claims are admissible in a courtroom, and what standard governs all human disputes, even life and death, is not neutral.
But it doesn't ask citizens to believe a law is divinely inspired. It just asks them to recognize the procedure was followed.
Procedure that dictates ultimate reality is substantive. If the state says chess is the only game allowed, and the rules of chess dictate who goes to prison and who gets executed, it's no longer just a neutral game. It is a worldview. Enfield's text preemptively dismantles this exact defense. When a legal system declares that enacted law is the only valid standard and systematically excludes natural law from constitutional reasoning, it is acting as an exclusive creed.
Calling it a creed feels like a rhetorical stretch, though.
Is it? Look at the structure. In this secular theocracy, the legislature acts as the priesthood, the statutes serve as the holy text, and the Supreme Court acts as the College of Cardinals, the final arbiters of reality. I cannot yield any ground here. Calling the exclusion of competing moral frameworks neutrality does not magically make it neutral. It is an undisclosed establishment of a belief system that demands absolute, unquestioning submission to state sovereignty.
Even if I grant that it functions similarly to a comprehensive worldview, which is a big concession, that procedural framework exists precisely because we disagree on ultimate moral truths. If positivism is a religion, it is the only one that allows a pluralistic society to survive without descending into sectarian warfare.
And that brings us perfectly to Enfield's kamikaze argument, which destroys the idea that positivism can safely govern a society at all. This argument demonstrates why positivism cannot sustain itself without destroying the very rights it claims to manage.
The kamikaze argument. Walk me through how Enfield sets that up.
The positivist framework detonates from the inside, using its own premises. Let's look at the founding document of the nation. The Declaration of Independence explicitly states that rights are endowed by a creator and are unalienable. This means they exist prior to the government. Positivism actively rejects this, arguing that rights are just legal permissions granted by the state through positive law.
Because from a positivist view, a right isn't actionable unless a legal system recognizes and enforces it.
Right, but follow that logic to its necessary conclusion. If rights are merely permissions granted by the state, then the state retains the inherent authority to revoke them. The positivist who defends the state's absolute authority to define something like personhood is actively destroying their own protections. They are flying a kamikaze mission into their own foundation.
You're talking specifically about the meta right of life here.
Yes, the right upon which all other rights depend. Enfield points to a brilliant, empirically observable standard, the scientifically documented zinc spark.
For those who might not be familiar with developmental biology, what exactly is the zinc spark?
It is quite literally a visible flash of zinc ions that erupts at the precise, scientifically observable moment of human fertilization. When the sperm enters the egg releases billions of zinc atoms in a literal spark that scientists can capture on camera under a microscope. It is not a philosophical abstraction. It's not a theological guess. It is the empirically verifiable biological beginning of a distinct living human organism.
Okay, so a biological threshold is crossed. But the law has always had to draw lines about when biological life achieves legal personhood.
And that is the fatal flaw of positivism. By allowing the state to define personhood at some arbitrary, politically negotiated point after this biological beginning, positivism permits the state to revoke the fundamental meta-right of life from an entire class of living human beings. And if the state has the philosophical authority to do that to one group of human beings based on a legal definition, it can logically do it to anyone. The positivist has absolutely no logical floor to stand on.
That's a compelling argument, but have you considered that the Constitution itself provides the floor for these rights? We don't need to import a rigid, universally binding natural law doctrine that bypasses the democratic process, because the Constitution restrains the state.
How does it restrain the state if the state is the one interpreting it?
Through provisions like the 14th Amendment's due process and equal protection clauses. Originalism and democratic legitimacy allows citizens to establish and refine these protections over time. The democratic process is how a pluralistic society resolves deeply contested moral questions, like when legal personhood should attach, without imposing a single transcendent philosophical answer from the bench. The constitutional floor is real, and it is enacted law.
That's an interesting point, though I would frame it differently, and I must stand firmly on my original premise here. Your defense relies on the idea that enacted law is stable enough to serve as a floor, but if the constitutional floor is just more enacted positive law, then it is just as contingent, just as temporary as the statutes it governs.
But it's much harder to amend the Constitution than to pass a statute. There is friction built into the system to protect that floor.
Friction is not an absolute barrier. Enacted law can be amended, or worse, simply reinterpreted away by the College of Cardinals, the Supreme Court. We have seen this exact mechanism before, most tragically in Dred Scott. The state, utilizing positive law, simply defined a class of biological human beings as non-persons to exclude them from constitutional protection.
Dred Scott was a horrific failure, but the democratic process eventually corrected it through the Reconstruction Amendments.
But under pure positivism, Dred Scott was entirely legal until it wasn't. If the state is allowed to define who counts as a person, we are left with exactly what C.S. Lewis warned about in his book The Abolition of Man. We are left with the conditioners.
The people in power who define value for everyone else.
Exactly. The conditioners hold power and arbitrarily define values and personhood for society, subject to no higher standard above themselves. I completely reject the compromise that democratic deliberation is sufficient when dealing with the meta-right of life. A right to life that does not protect a biologically distinct human organism from its inception, from that zinc spark, is not an unalienable right. It is a conditional privilege. And positivism provides no non-arbitrary stopping point to prevent the state from narrowing that privilege whenever it sees fit.
I'm sorry, but I just don't buy that. Let me tell you why. If we accept your premise and Enfield's premise and admit natural law into constitutional interpretation as a binding operative constraint on enacted law, we run headlong into the very Establishment Clause violation you are accusing positivism of committing.
How so? Acknowledging an inherent limit on state power is the exact opposite of establishing a state religion.
Because natural law, as it has been historically practiced and understood in the Western legal tradition, is inextricably linked to theological roots. The Declaration of Independence itself, which you cited earlier, explicitly appeals to nature's God and a creator. If courts begin striking down democratically enacted positive laws because judges believe those laws violate a transcendent divine moral order, the state is functionally establishing theism.
I don't believe that naturally follows at all.
It absolutely follows. If you use natural law to override the legislature, you are establishing the theism, if not Christianity specifically, as the governing framework of the nation. Positivism, for all its perceived philosophical coldness and procedural distance, protects the state from becoming an instrument of religious enforcement. It maintains the wall of separation.
I see why you think that, but let me give you a different perspective, because that fear that natural law is just a Trojan horse for theology is historically and empirically false.
You don't think natural law is historically tied to Aquinas and theological frameworks?
It has those roots, yes, but the argument that natural law is inseparable from theology completely ignores the vast intellectual history of secular natural law. We don't need to invoke a deity to recognize unalienable constraints on human behavior. Look at Immanuel Kant.
The categorical imperative?
Exactly. Kant derived inherent human dignity and universal moral duties from purely secular, rationalist premises. He figured out universal rules using pure reason. No God required. Look at John Rawls in the 20th century. He derived protection for the most vulnerable members of society using the veil of ignorance, a secular political thought experiment where you design a just society without knowing if you'll be rich, poor, or vulnerable in that society. That is natural law arriving through pure logic.
Those are philosophical frameworks, though, not operative legal standards.
But they have been operative legal standards when positive law completely failed humanity. Crucially, look at the Nuremberg Tribunal. This is the ultimate proof that Enfield's critique is vital, and I will not yield on this historical reality.
The prosecution of Nazi officials after World War II.
Yes. Think about what that actually means on the ground. Everything the regime did in the 1930s and 40s was entirely legal under the positive law of the Third Reich. The legislature passed the laws. The judges enforced them. It was the rule of recognition working perfectly. When the Allies put those officials on trial, the defense was pure legal positivism. We were just following the validly enacted laws of our sovereign state.
And the tribunal had to reject that defense.
They had to. To prosecute those atrocities, the world was forced to appeal to a higher, secular, natural law standard of human rights. They did so without invoking any theological authority. They essentially said, there is a floor of human dignity that no state law can violate. If positivism is true, Nuremberg was an illegal, retroactive show trial. We have to choose.
That is a heavy historical anchor. But how does that translate to the American constitutional framework without giving judges unchecked power to act as philosophers?
It translates by recognizing what the Constitution was actually built to do. Restoring the Declaration's natural law framework isn't a judicial power grab. In fact, John Bingham, the primary author of the 14th Amendment, documented in his explicit legislative intent that he was constitutionalizing the principles of the Declaration of Independence.
So he was binding positive law to that natural law ceiling.
Exactly. It serves as an essential ceiling on government power. A government that acknowledges unalienable rights existing prior to its own authority is a government admitting it is limited. Restoring natural law doesn't force the state to act as a church. It is the absolute only structural mechanism that prevents the state from becoming its own church, accountable to nothing but its own power. The state simply cannot be its own standard.
And while I acknowledge that Enfield's texts provide a brilliantly constructed and genuinely provocative critique of state power, and you have defended it fiercely, we must recognize the profound risks of his proposed remedy. Dismantling the procedural neutrality of legal positivism risks completely destabilizing our pluralistic legal order.
I argue the order is already destabilized because it has no foundational anchor.
But the tension between unalienable moral truths and enacted democratic laws is not a bug to be eradicated. It is a feature of our republic that must be carefully managed. Declaring the entire operational framework of the American legal system to be an unconstitutional religion under the First Amendment is a massive leap. It threatens to unravel the predictability and democratic legitimacy that positive law provides. The procedural framework exists with all its flaws precisely because millions of citizens fundamentally disagree on ultimate moral truth.
But as the source material forces us to confront, the internal logic of legal positivism leaves it with no floor to stand on. By functionally operating as a religion under the Supreme Court's own Welsh test, and by converting unalienable rights into revocable state permissions, the current positivist framework fundamentally betrays the architecture of the Constitution. The kamikaze argument demonstrates that a system relying solely on positive law cannot prohibit anything with genuine normative force. It can only describe what is currently enforced by the people with the guns.
Which is a terrifying thought if the people with the guns change their minds about your rights.
Exactly.
Acknowledging natural law and recognizing the inherent personhood of a distinct human organism starting empirically at the documented zinc spark is not an imposition of theology. It is the only logical exit from a system that otherwise claims absolute, unchecked sovereignty. We must recognize the ceiling on state power, or we must honestly accept that all our fundamental rights are merely temporary privileges waiting to be revoked.
The intellectual challenge presented by this material really is profound. It forces you out of your comfort zone. Whether one views the law as a neutral, pragmatic tool for managing a diverse society, or as an instrument that must be anchored to an absolute moral reality to remain legitimate, these structural questions strike at the very heart of what it means to possess a right in the first place.
I completely agree. The texts demand deep, ongoing scrutiny of our assumptions about power, authority, and the fundamental nature of law itself. It forces us to ask very uncomfortable questions about the foundations we stand on.
There are no easy answers here, only vital questions.
There is certainly much more to explore in this material. We will leave it to you, the listener, to examine the frameworks that govern your own understanding of rights, laws, and the ultimate limits of state power. Thank you for joining us for the debate.
Welcome to The Debate. Today we are examining the foundational nature of the American legal system.
Right. Specifically, we're exploring whether legal positivism,
The philosophy that law is merely what the state validly enacts.
exactly, whether that functions as an unconstitutional established religion.
And whether natural law mandates the absolute legal recognition of unborn personhood. Now, this intellectual exchange emerges directly from the profoundly challenging Lawless by Merit body of work by Zachary David Enfield.
It really is a massive piece of work, and our central question today is stark. Has the state established a secular theocracy by making legal positivism the exclusive framework of constitutional interpretation,
Thereby unlawfully converting unalienable rights into revocable state permissions? I represent the advocacy position here. I'll be arguing rigidly that legal positivism meets the Supreme Court's own functional test for an established religion, and that the 14th Amendment, which is grounded in natural law and the incontrovertible biological reality of the zinc spark, demands absolute protection for the unborn without any legal compromise.
And I represent the dissenting position. I am arguing that legal positivism is, well, it's a neutral, necessary procedural methodology for pluralistic governance, and that importing natural law into constitutional jurisprudence actually risks the very religious establishment the First Amendment was designed to prevent.
To set the foundation for our discussion, I have to state clearly that the positivist framework dominating our courts today is completely void. I will make no concessions to its premises because it operates under a massive deception.
A deception?
Yes. Legal positivism is constantly sold to us as a neutral methodology, just a set of rules for how a society operates. It is not. It is an established church. It is a secular theocracy. Under the Supreme Court's own functional test for religion, which was established in a case called Torcaso v. Watkins and then formalized in Welsh v. United States, positivism functions exactly like a religion.
Okay.
It provides a governing account of ultimate reality. It acts as the final authority. It demands mandatory adherence from citizens, and it structurally excludes any competing frameworks. Beyond that, the rights we hold as human beings are endowed, not granted by a government. The very second the state claims the authority to define your rights, it claims the authority to revoke them. The 14th Amendment was written by John Bingham specifically to constitutionalize the Declaration of Independence's natural law framework.
Right, the meta right.
Exactly. That creates what Enfield calls a meta right to life, because modern science now empirically documents the precise beginning of a distinct human organism at fertilization through what is known as the zinc spark. The unborn are constitutional persons. There is no middle ground, and the state has no authority to pretend otherwise.
Okay, you call it a secular theocracy, but framing positivism as a religion is, well, it's a massive category error. Positivism is not a belief system. It's essentially just the plumbing of the legal house. The legal philosopher H.L.A. Hart famously called this a rule of recognition.
A procedural rule.
Right. It's simply a system for identifying what actually counts as a law in a complex modern society. When you try to apply the Welsh test to this, you're taking a legal standard that the Supreme Court specifically designed for individual conscientious objectives during the Vietnam War, people whose deep moral beliefs functioned like a religion, and you're applying it to an entire institutional framework. That fundamentally misrepresents both the test and the nature of jurisprudence itself.
I disagree.
Let me just add, admitting natural law into constitutional interpretation is a remarkably dangerous proposition. It opens the door to subjective, often theistic moralizing. That is exactly what the Establishment Clause's wall of separation seeks to prevent. If we look at the originalist interpretations of the 14th Amendment in 1868, they simply did not include the unborn in the definition of a person. Concepts like viability provide a necessary, medically grounded, and highly pragmatic legal threshold for balancing competing rights in a democracy.
I'm not convinced by that line of reasoning because the claim of neutrality is positivism's most effective and insidious concealment. When you say positivism just describes the plumbing, that it merely shows how a legal system works without prescribing what it should value, you are completely ignoring the fact that it makes a massive, substantive claim about ultimate reality.
How so? It just identifies the law.
It claims that absolutely nothing above the state's enacted law has operative force. That is a theological claim. Let's actually look at those 4 questions of the Welsh test and apply them to this institutional framework, because the fit is exact. First, does it provide a governing account of ultimate reality? Yes, it declares enacted law as the final truth. Second, does it occupy the place of final authority? Absolutely. The Supreme Court acts as a college of cardinals, issuing binding doctrine from which there is no appeal.
That's quite a metaphor.
It's an accurate one. Third, is adherence mandatory? Yes, you are subject to the state's coercive power, whether you believe its creed or not. Fourth, does it exclude competing accounts? Systematically. It systematically excludes natural law from the courtroom. In this system, high school civics classes operate as Sunday school for the creed of state sovereignty. Excluding natural law isn't neutrality. It is the explicit establishment of a secular creed. I cannot give ground on this premise.
But the entire purpose of a positivist framework is to allow a pluralistic society to function without religious or philosophical domination. By relying on the written constitution as the ultimate floor, we prevent tyranny. Think about what happens if we abandon that. If we say the written law must be measured against some unwritten natural law, we invite unaccountable judges to act as what the author C.S. Lewis called conditioners.
The conditioners?
Yes. These conditioners would impose their own moral preferences on the entire populace, while claiming they are merely discovering universal truths in the ether. The written constitution, interpreted through enacted positive law, provides a stable, objective baseline. Without it, who gets to decide what natural law actually dictates? Is it the judge's personal philosophy, their religious background? It quickly becomes an exercise in raw judicial power disguised as moral philosophy.
I hear the fear of unaccountable judges, I really do. But the positivist framework destroys itself from the inside using exactly that logic. Enfield refers to this as the kamikaze argument, and it completely dismantles the positivist safety net. Let's walk through it.
Go ahead.
If the state is the entity that grants personhood, as it did in Dobbs by removing federal protections, or as it did historically in Dred Scott by defining an entire class of human beings as non-persons, then the state can redefine anyone's personhood. A positivist defending their own liberty relies on the very same void foundation they use to deny the unborn's life. Think about that. If the state's authority, operating through correct legislative procedure, is sufficient to ground the denial of an unborn child's right to life, it is structurally sufficient to ground the denial of your liberty. You have detonated the floor beneath your own feet.
Wait, hold on. You're equating the procedural mechanisms of modern democracy with Dred Scott?
Absolutely, because the underlying philosophy is identical, that rights are whatever the state says they are. William Blackstone made this clear centuries ago, and the Nuremberg Tribunal explicitly affirmed it in the modern era. At Nuremberg, the defense was, literally, we followed the positive law of our nation. The tribunal rejected that entirely, establishing that human law is of no validity if it is contrary to natural law.
Nuremberg was dealing with unprecedented atrocities, not the functional, day-to-day legislation of a republic.
The principle remains the same. If rights are merely permissions granted by the state rather than endowments from a source above the state, then no one is safe. You mentioned C.S. Lewis and the conditioners. The conditioners are not the natural law theorists. The true conditioners are the positivist judges who believe they are accountable to absolutely nothing above their own legal definitions.
That's a compelling argument. But have you considered the sheer chaos of discarding established procedural thresholds in American law? Let us look at this from a pragmatic and originalist standpoint. The 14th Amendment's original public meaning in 1868 simply did not extend the word person to fetuses. To read that into the text now, over a century and a half later, is a massive judicial leap.
It is not a leap if you understand the biological reality.
But practically speaking, the concept of viability is a reasonable biological compromise. It balances the profound competing interests at play in a diverse society. Viability recognizes a threshold where the developing organism can survive outside the womb. That provides a medically grounded marker that modern society can actually organize its legal principles around. If we abandon viability and procedural thresholds entirely, we dismantle the very predictability that makes the rule of law possible in the first place.
I reject the premise that we can compromise on the fundamental nature of existence. There is no compromise to be had when dealing with the meta right to life. You mentioned original meaning. The 14th Amendment's author, John Bingham, explicitly intended to constitutionalize the principles of the Declaration of Independence. The Declaration states that all men are created equal. It points to a moment of origin, not a moment of birth, and certainly not a moment of viability. And today, science has documented that exact origin.
Are you referring to the zinc spark?
Yes, the zinc spark. In 2016, researchers at Northwestern University documented it. It is an observable, empirical release of zinc ions that flashes like light at the exact moment of fertilization. This isn't abstract philosophy. This is incontrovertible scientific proof of the initiation of a distinct, genetically unique human organism.
Right, but
Viability is a mere technological accident. It is entirely dependent on medical advancements. If you attach the right to life to viability, it means the exact same human organism would be a constitutional person today, but 50 years ago they wouldn't be, simply because our neonatal incubators got better. That is intellectually bankrupt. The meta right to life is the absolute precondition for all other rights. Denying it before viability eliminates the subject before they can even cross your arbitrary threshold. You simply cannot have a constitutional system that claims to protect rights while legally permitting the destruction of the rights holder.
let's pause on the science for a moment. Because even with the certainty you are assigning to the zinc spark, we must return to the structural limitations of American jurisprudence. You keep referencing the Declaration of Independence. Relying on the Declaration's nature's God or a creator to ground constitutional rights is inherently theistic. Utilizing it as binding law violates the Establishment Clause.
It doesn't.
It absolutely does. The founders deliberately created a secular constitution. They built a wall of separation precisely because they looked at European history and saw the bloodshed and tyranny that resulted from governments enforcing theological premises. If we require the legal system to acknowledge a creator as the source of rights, we are establishing a religious premise as the mandatory foundation of American law. The positivist framework, while perhaps imperfect and highly procedural, is the necessary architecture of modern governance specifically because it avoids this exact Establishment Clause violation.
Your framing fundamentally misunderstands both natural law and the Establishment Clause itself, and I will not concede that natural law is a theological imposition. It is not. Natural law is the convergent conclusion of human civilization. Look at the philosophers. Immanuel Kant derived inherent human dignity from purely secular rationalist premises, the categorical imperative. John Rawls derived protection for the most vulnerable through secular political philosophy and the veil of ignorance.
But those are philosophical frameworks, not binding constitutional law.
The Nuremberg Tribunal, which we just discussed, applied natural law without invoking any specific deity to convict war criminals. Natural law is the objective moral reality that rights precede the state, period.
But by demanding the state recognize a higher power granting rights, you are blurring the line the founders drew.
No, the founders drew that line to protect exactly what I'm talking about. The Establishment Clause was designed by Madison and Jefferson as a bidirectional firewall. Yes, it was meant to protect the state from ecclesial capture, to keep the church from running the government. But it was equally designed to protect the conscience from state capture. When you use the Establishment Clause to exclude natural law from our jurisprudence, you turn that firewall into a furnace. You establish the state itself as God.
That is a very heavy accusation.
It's the reality, because a government that acknowledges no authority above itself claims absolute sovereignty. By systematically excluding the natural law framework that John Bingham explicitly built into the 14th Amendment, positivism operates as a secular theocracy. It has declared its own positive law as the only admissible creed.
But a state governed by positive law is accountable to its people through democratic processes and the amendment mechanism. It doesn't claim to be God. It claims to be a republic. When the Supreme Court leaves a deeply contested moral issue to the states, it is not acting as a secular theocracy. It is exercising judicial restraint. It is recognizing that in a pluralistic society, liking consensus on the metaphysical status of the unborn, the democratic process, governed by enacted law, is the only legitimate way to navigate the disagreement.
Democracy has limits.
If we impose a universal natural law mandate that criminalizes abortion nationwide based on this zinc spark, we are completely bypassing the democratic consensus that the Constitution relies upon. We are trading the imperfect machinery of democracy for the absolute dictates of a philosophical framework that much of the country simply does not accept.
The democratic process cannot vote an unalienable right out of existence. That is the very definition of the word unalienable. The moment a governmental body treats the right to life as a policy preference subject to democratic determination, it has stepped entirely outside the framework of the American Republic. Let me be perfectly clear. If 51% of the population votes to redefine a class of human organisms out of existence, that is not democracy functioning correctly. That is tyranny by majority.
It's procedural governance.
The positivist who says the state's definition of personhood governs because the majority voted for it has absolutely no principled argument against any historical atrocity that was legally enacted through a democratic or legislative process. The state that granted you your rights as a permission can vote to revoke them tomorrow.
I must insist that equating the procedural reliance on positive law with historical atrocities ignores the internal constraints of the Constitution itself. You speak as if positive law is a blank check for tyranny, but the Constitution has equal protection clauses, due process clauses, and an entire Bill of Rights that courts actively enforce to protect minorities from majority tyranny. It achieves this not by appealing to some unwritten natural law that lives in the clouds, but by strictly applying the written, enacted text. When we rely on the text, we have a predictable, measurable standard.
A measurement cannot measure itself. It's a logical impossibility. A government cannot be both the authority that defines rights and the standard against which its own authority is measured. When the state removes the external measurement of natural law, it places itself above accountability entirely. You bring up the text. Let's look at the text of the 14th Amendment. It says person.
Yes.
It takes the category of person as a given, external reality that the state is obligated to protect. It does not offer a blank check for the state to define what a person is. Science proves the biologically distinct human organism exists at the exact moment of the zinc spark. Therefore, the text protects that person. Any positive law shield that state actors or doctors rely upon to deprive that person of life is what lawyers call void ab initio. It is legally invalid from the absolute beginning. It has zero validity because it contradicts the higher standard that the Constitution itself was built upon. I will not yield to a legal philosophy that treats human life as a procedural technicality.
To summarize my position in light of this incredibly rigorous discussion, legal positivism, while certainly subject to philosophical critique, remains the necessary procedural architecture of modern American government. The Constitution must rely on enacted law, defined thresholds like viability, and democratic consensus. We simply cannot rely on transcendent, unwritten philosophical frameworks, no matter how scientifically we try to dress them up with references to a zinc spark. Doing so risks the subjective imposition of morality that the Establishment Clause explicitly forbids. A pluralistic society requires a neutral rule of recognition to function, and abandoning that invites legal and societal chaos.
And to summarize my unyielding stance, legal positivism is a self-destructing secular theocracy. The natural law framework is not a theological imposition, but the indispensable external measurement required to keep any government accountable to human rights. The empirically documented biological reality of the zinc spark, combined with the 14th Amendment's explicit text, demands the absolute protection of the unborn. Positive law provides no valid shield for those who violate this meta right. A legal system that claims to grant rights as permissions rather than secure endowed rights has built a floor over an abyss, and we are seeing the consequences.
We clearly have a profound and fundamental disagreement regarding whether the Constitution must be read through a transcendent natural law lens or a strict procedural positivist one. This cuts to the very core of how we understand law, authority, and human rights.
Indeed, it does. The depth of Zachary David Enfield's Lawless by Merit challenges the very foundations of how we interpret the state's power. Listeners have an immense amount to explore in these philosophical and structural arguments, and the implications touch every single aspect of American jurisprudence. Thank you for joining us on The Debate. We leave you to weigh the stark contrast in legal philosophy for yourself.
Hey everyone! Today we are diving into a really fascinating and pretty radical legal argument from Zachary David Enfield. The basic idea? That the modern American legal system might be operating under a hidden and unconstitutional state religion. So the whole thing really kicks off with this single, pretty startling question. What if the American legal system actually has an unacknowledged state religion? It's a huge claim. So let's unpack how it gets there. And boom, there it is. That's the core thesis right there. The author is claiming that if you use the Supreme Court's own rules, the main legal philosophy in America today is, for all intents and purposes, a religion. So let's break down how he builds this case, step by step. All right, to really get a handle on this argument, we first need to get clear on two key concepts that are right at the heart of it, at least as the source presents them. Okay, so first up, we have this thing called legal positivism. The author identifies this as basically the dominant way of thinking in law today. And, to put it simply, it's the idea that a law is valid not because it's good or moral, but just because it was created through the correct process by the right people. Its authority comes from procedure, not from some higher truth. And this is the constitutional tool the author uses to build his entire case. He's pointing straight to the Establishment Clause, but he argues it applies in a way that most people don't really think about. Okay, now this is where the argument takes a really interesting turn. See, the author isn't just inventing some new standard to make his point. He claims that he's using a test for what religion even means that was created by the Supreme Court itself. The source material points us to a couple of landmark cases back in the 60s and 70s, and these are absolutely critical because this is where the court legally stretched the definition of religion way beyond just traditional belief in God. They basically said that deeply held moral or ethical beliefs could count too. So the crucial point is this. According to the source, the test isn't about theology or whether something calls itself a religion. It's all about the function of the belief system. Does it serve as the ultimate, final authority in someone's life, the same way God does for a religious person? So the author takes that functional test and boils it down into 4 direct questions. He asks, does legal positivism define ultimate reality for us? Is it the final authority? Is it mandatory for everyone? And does it push out any competing ideas? Then he turns right around and applies that very test to legal positivism itself. And when he applies this test, the author argues that legal positivism answers yes to every single question. It defines legal reality, right? The Supreme Court is its final arbiter. Its rules are absolutely mandatory for all of us, and it kicks rival philosophies like natural law right out of the courtroom. So, according to the source, it fits the Supreme Court's own definition of a religion perfectly. And that leads to this. Well, this brilliant and pretty biting conclusion from the author. He's essentially arguing the Supreme Court is caught in its own trap, that by its own logic, it has established a state religion, violating the First Amendment. Okay, now we get to what is maybe the most dramatic claim, which the author calls the kamikaze argument. The idea here isn't just that legal positivism fails some external test. It's that it is actually designed to destroy itself from within. He calls it the kamikaze argument because the philosophy's own core principles are what supposedly cause it to crash and burn. It's a fascinating idea, this notion of a system that basically detonates itself using its own logic. To show how this might work, the author uses a very contentious example. He points to laws based solely on state authority, like those concerning the unborn, and argues that if state power alone is the foundation for those laws, then that exact same foundation is what protects all of our liberties. He claims the legal ground for both is identical, and because of that, it's incredibly unstable. The author uses this powerful metaphor to describe what he sees as a deep contradiction. The argument is, you can't rely on the system's authority to protect your rights while also arguing its authority is groundless when you don't like the outcome. Logically, he claims the whole floor just collapses. And this gets to another really crucial point from the source material. He makes a distinction between a right and a permission. A right that's endowed by some higher authority is meant to be permanent. But a permission that's just granted by the state, well, that's temporary. It can be withdrawn. The author's claim is that legal positivism turns all of our fundamental rights into these fragile, revocable permissions. So, if the source material is arguing that the current system is internally flawed and basically groundless, where does that leave us? What's the alternative that he presents? And this is presented not really as a religious point, but as a structural one for building a limited government. The idea is, without some external standard to measure itself against, the state just becomes its own highest authority, its own absolute final word. The author calls this alternative the unbroken chain. It's a hierarchy of authority that's anchored by natural law, this idea of a universal moral reality. This, he argues, provides the external grounding that legal positivism is missing, making sure each level of law is accountable to a standard above it. And this is really the final takeaway on his proposed solution. The author's whole point is that by acknowledging an authority higher than itself, the state actually puts a ceiling on its own power, and that act of limitation is what keeps it from becoming the absolute, established church that he's warning us about. And so the author leaves us with this final, really challenging question. A legal system has to be grounded in something. If not in itself, then where? It's a fundamental question about the very source of law. Thanks for joining me for this explainer.